Welcome to We Solve Problems with your host, James D. Bennett II. In each episode, we'll share educational insights to motivate manufacturers to innovate. You can find this show on YouTube, LinkedIn, Apple Podcasts, Spotify, and on www.innovativsolutions.org. Now, here's the host of We Solve Problems, James D. Bennett II.
Good morning, and welcome to the We Solve Problems podcast. Where we,
Hi, good morning.
good morning. Where we inform of the existing technology, the trend of the R&D for that technology, and the financial incentive to help mitigate risk of innovation. I'm your host, James Bennett. Today we're talking about the patent filing process in India with Dr. Prachi Chopra, who is a patent agent, founder and director of Intellectual Bastion LLP. Dr. Chopra, could you give us a brief summary of your background, please?
Okay, I'm actually founder of company Intellect Bastion in India, and we help inventors, entrepreneurs, and people from universities and institutes. We help them to get patents, trademarks, copyrights, designs. Actually, in India, because you are in a different country, I must mention it that we have in India patents and designs that separate different intellectual property rights. It's not utility patents and design patents as in US and many other countries. It's so we help inventors and entrepreneurs and all the people from research and development society, research and development community get intellectual property rights over their work, get them assets. So this is what we do. And as a part of my educational qualifications, I have done I have engineering background. I've done BTech, MTech, and PhD in electronics and communication. And then I was just motivated to help people who belong to my community, who are engineers. They have done some inventions and they want to protect it. I was not motivated to be an inventor as such, but I wanted to help these people. So I passed the patent agent exam and become a licensed patent agent, and then I'm now trying to help the people from R&D community to get patents and trademarks, yeah, and various other intellectual property rights.
Okay, then, that's quite a background, and that's why I brought you on as a guest today, and that's why I believe it's important to hear what you have to say. Now, to put today's podcast into context, a patent is a type of intellectual property that gives its owner the legal right to exclude others from making, using, or selling an invention for a limited period of time. In most countries, patent rights fall under private law, and the patent holder must sue someone infringing the patent in order to enforce their rights. Patents have a positive effect on society because they promote innovation and help develop new products. But the procedure for granting patents, requirements placed on the patentee, and the extent of the exclusive rights vary between countries according to national laws and international agreements. But what about these other countries? In India, for example, the provisions relating to registration and enforcement of patents are contained under the Patent Act 1970 and its corresponding rules, namely Patent Rules 2003. But who in India is permitted to apply for a patent for an invention, and what is the term of a patent in India? Here to answer those questions and more is Dr. Chopra. Dr. Chopra, could you please explain to us who can file for a patent in India and what is the patent registration process?
Okay, so if I talk broadly in all countries, it's something which is almost similar in all the countries, but actually varies in specific countries that how we have to file a patent application. Broadly, we can say it is similar and same kind of in all the countries, but there are certain differences. So if I specifically talk about India, in India, who can file a patent? Patent can be filed at any person who has done some inventive work and he wants to protect it as a legal right. That person is allowed to file a patent, or someone on his behalf can file a patent. His legal representative can file a patent, or for the invention that he or she has done. If he or she doesn't want to, then so inventors can file patent application. And how they can file a patent application? Firstly, you should be fully able to tell the patent office about your invention descriptively in terms of a written application, that what your invention is. You should be able to explain your invention. If you're ready with your invention, if at all you're not even ready with the invention, there is other separate procedure to file a provisional patent application, and then in a year you can file a complete patent application. There are a few rules and in the act, how can we do that. But if I simply talk about the process, you should be ready with your invention and how your invention works. You should be able to describe in terms of the figures what your invention is, what is the summary, what background you have researched on, and are you what problem exactly you have solved, and what exactly you are doing in that invention. You should be able to explain it as a written application and in on as drawings. So if you're ready with that, that's the right time to file a patent application, a complete patent application, I must specify here. So to once we file the patent application, uh, it may be filed by an inventor by himself, or maybe you can ask for a patent agent or a patent attorney to file the patent application on your behalf, because it requires a lot of intelligence, and it's something which it's an art which you gain over the years. So people usually hire agents and attorneys. They do some background research that to find out exactly what your invention is, because inventors see their whole invention as something which is novel, but it is not always. So the the main part of your invention, where novelty lies, where it actually is the work you have done, which you can protect, that is done by doing background research, that is done by professionals. And then we find out where exactly is the novelty. We draft the claims, we completely draft the patent application, we prepare the forms are prepared and assigned by inventors, and power of attorney is signed. So this is the whole background process which happens before the final filing. And once this is done, when then we file at Indian Patent Office. This is, I think, and I just think that this is something which is done in each and every patent office, not only in India and in other countries as well. So once this is done, then what happens may differ in some countries, is like once we file the patent application in India, the patent applications are not automatically examined. This is something different from US, I can say, or some other countries. They are not automatically examined. You have to file another application asking the patent office to examine your patent application. Until you file that application, the patent application will only be published on completion of 18 months from the date of priority. Date of priority for the inventors, I must define, is the date of your first filing, on which you first file the patent application. So once the patent application is filed, then we file, if you want to get it examined, we file the examination request within 48 months from the date of first filing. And then the patent application is examined usually in another 2 3 years, 2 3 years, or maybe sometimes 1 year also, if the process is a little fast. These days Indian patent office is trying to hire more examiners, so as the delay can be reduced, and it depends upon the workload and work culture at Indian patent office actually. Once you get the examination report, it's called examination report here in India, we usually call it office action, I think, in USPTO. So once we receive that report, we have to prepare a response considering what all objections are stated by the examiner, and we either amend or argue depending upon our thinking behind what exactly examiner is saying and what we think and what inventor think. We actually collaborate with the we have a discussion, thoughtful discussion with the inventor, what exactly they want based on the examiner's objections, and how we should draft it, we should argue or amend, and depending on what exactly are their future aims, what they foresee their invention, how they foresee how they think want to commercialize it, and how they want to commercialize. Depending on this, we draft the response, and then once it is filed, it is either accepted or maybe if the examiner is not convinced, he may ask for a hearing, one-to-one hearing. Virtually, it is done in India usually. So then there is a hearing part, and we get a notification about it, and then once the hearing is done, it is finally decided with the patent office another few months if the patent application can be accepted or rejected. So this is the very usual process which happens in India. Timelines are different for each and every process, and it depends upon what exactly inventor wants. There can be different roadmaps for different directions for how we process the final application. Yeah.
I see. I see. And just listening to you talk, it sounds pretty similar to the U.S. Sequence of patent prosecution. That the sequence of the patent prosecution process in the U.S. is generally the same, and it goes something like this. And this is a textbook sequence. The inventor drafts an invention disclosure, which describes the invention. Then the inventor discusses the invention with the attorney or the agent. The attorney or the agent prepares an application. The inventor reviews the application draft and make any changes according to what he perceives the invention to be. Then the attorney or the agent prepares the final draft and related documents and files the application. That's what we call prosecution.
Yeah.
And the patent office examines the application and provides any responses to the invention. I think the difference that you have there is that you have to request to be examined.
Yeah. Yeah.
We do have to do that in the U.S. Then after that, then the attorney or the agent and the inventor respond to the patent office accordingly, whatever those office actions are. And the patent office reviews the responses. Once everything is cleared there, then the patent office allows the application. And then once that is done, then the inventor pays the issue fee, and the patent office issues a patent for the invention. So that's pretty much what the U.S. process is. So it sounds pretty similar. I think the only difference that I noted there is that in your country, in India, you have to request an examination.
Yes, this is a very big difference.
Yeah,
In India, it is not automatic. Yeah.
yeah. So there's where the big difference is. Okay, then, given that, in the U.S., the initial eligibility requirements for a patent are the invention must have utility, it must be novel, and it must be non-obvious. So now, what are the eligibility requirements for filing a patent in India? I mean, are they the
Yeah.
same? Are they along the same
Yeah.
line there with utility, non-obviousness, and novelty? Is that about pretty much it? Oh, this is
Yeah. Actually, it is same not only in India, but I think in all other countries which are a part of TRIPS agreement. I suppose I'm not aware about other countries, but definitely which belong to Paris Convention and all. They actually have same types of eligibility criteria, so that there is uniformity amongst all the countries. But I must mention here the wordings may be different. In India, we say the invention should be novel, it should have inventive step, and it should have industrial applicability, which maybe in different countries it is industrial applicability may be informed as it should have utility, and inventive step may be informed as it should be non-obvious, but it means one and the same thing. It's about what wordings the office uses to describe the one and the same thing. So it should be novel. Firstly, it should not be any of the prior arts, prior publications anywhere globally. It should be very novel. It should be one and only, that means. And then it should be having inventive step, which actually means it should be not non obvious. It should have something which the inventor has done on his own, maybe just a single step, which is very unique and inventive, but it should be invented. And this is where the claims are drafted upon. So it's actually that which defines what is the center of the claims a drafter has to draft, where the claims should be centralized. That is decided by the inventive step, and around that the drafting of the claims is done. And third is it should have industrial applicability. If it is of no use to the industry, it's of no use for the society, and there is no need to have a patent over it. So one thing, any invention which can be used with the society for the benefit of the society, and then only it is patent eligible. So this is the requirement, basic requirement. Other than this, if I talk specifically about India, there is section 3 and 4 of Indian Patent Act, which defines a few number of types of inventions which are not eligible as patents. This is very specific to India, because just to just to safeguard the rights of the general public, so that they are they can easily have medicines. We have certain types of inventions which are not easily given patent over in the pharma side. Some inventions related to computer science, also mathematical algorithms maybe, and some inventions like related to maybe some inventions, artistic inventions that can be copyrighted, musical inventions, these type of inventions we can have copyright over them. And software inventions we can have a copyright, but patents, to get a patent, it should be something which is having some physical components and technical advancement, much technical advancement in the tangible form. Then only patent can be we can get a patent in India. Few other inventions, but broadly the whole thing is same like in other countries. Plus, other than this, the description part should be within the scope of the claims, and it should be clear, concise, scope should be there, and claims should be drafted well in order in antecedent basis. These are the basic requirements, I think, in other countries as well. So this is the whole broad requirement kind of a thing to get a patent in India.
Okay, well, the only difference I detected there is, I think you said the invention must be applicable in industry somehow or another. Is that correct?
If you are talking about section 3, which where I inform some inventions which are not eligible as patent, yes, there is a difference. Other than this, broadly novelty, industrial applicability, and inventive step, all these things, wordings may be different, but it is one and the same thing like in other countries. But few inventions which cannot be which are not patentable in India, these are few inventions in Indian Patent Act, like in pharma side, unless a medicine is not having therapeutic efficiency, the other forms of a same medicine cannot be given patent over. We cannot get a patent over them. So, but this is not the case in USPTO. I think that if we change the form, so it actually it stops evergreening of inventions, because in India it's very one a medicine can be very costly for a person which is living here in India. So for that purpose, we have certain restrictions over inventions which are from pharma side, and that's why it is very important here. There are certain restrictions here in India related to pharma side. Yeah.
I see. Okay, now the person has filed a patent. He's met all the requirements, etc. Uh, and of course, everybody's anxious to get their invention certified by the approving office. Now, in the U.S., in a general sense, getting a patent might take a few months or maybe a few years, depending on its novelty. How long does it take to get a patent in India, and how might the inventor expedite the process?
In India, usually once we file the patent application, as is the usual scenario, it gets published within on completion of 18 months. And usually, if I talk about examination, it takes 2 to 3 years minimum. It can be expedited, definitely. I'll talk about this, but then 2 to 3 years. It usually takes for the whole process to end up with the application, maybe 4 years, I can say, but 2 to 4 years, it's the average time period. How to expedite? Yes, it is possible. If some applications, domestic applications or international applications, there are procedures to expedite it. There is a provision of filing expedited examination request here in India. This can be filed. It is costly. It is double the fees of a normal examination request. It costs INR 8,000 rupees, not much as per USPTO currency, but yes, it may be costly as per Indian currency, because it is double the rate of a normal examination application. But it helps you get the patent application examined in half a time, which usually may take maybe or lesser than that, even lesser than that, which is the normal time period to get a patent application examined. So you can expedite the process, but not all people can go through the process of expedited examination request. There are certain categories of people only who can apply for this request, who are startups or small entities, or maybe if one of the applicants is a women applicant, then that application can be requested under expedited examination request. Or if it comes under some international treaty like PPH, some patent prosecution highway kind of treaty, between that collaboration agreement, that a patent application resides in that. And if it belongs to some government organization, government company, it's a part of government initiative, government financed company, such kind of applications. Or if the application has kept India as international search authority, or international patent examination authority, if it belongs to some other country, or maybe India, maybe from India as well. So if such kind of I think I have not missed any. If there may be one or two, maybe I have missed, but these are the categories of people who can file for expedited examination request. Now, other than this, if it is a application filed under patent corporation treaty for inventors, I must define this, that those applications are these are the applications which are filed as an international application, and then they are distributed, segregated among different channelized in different countries to get a patent over them in those countries. But it is an international application under patent corporation treaty. And then we do national phase applications. So these applications can there is a these are only examined on completion of 31 months from the priority date. So if an inventor wants to get this examined before 31 months, then there is a process of filing express examination request in India. So this is a process of expediting the examination of patent applications filed under PCT, filed under PCT. So this can be applied instead of as a part of expedited examination request. Other than this, if someone wants from Japan, if someone wants to expedite the examination, I cannot say about other countries. We have patent prosecution highway collaboration agreement kind of a thing with Japan, only with Japan as of now, which maybe we should have other countries as well. So if the application is a part of the PPH, then that can also be expedited through different means, different ways. So this is how these are the three main ways. And we can apply for early publication also. We should actually apply for early publication also if we are trying to go through these expedited examination procedures, because unless the patent application is published, it cannot be examined. So we have to reduce the timeline from 18 months to 1 month through early publication. By filing early publication, there is a procedure of early publication. So I think these are some terms of early publication, expedited examination, express examination, and the rules of these are different from other countries. I just would like to know from you if it is something same or different in US.
It sounds very similar. I don't see
Okay.
any big differences anywhere there. That that as to what takes place all the way up to and including the publish period, which is a year and a half after filing, etc. All of those things seem to mirror one another. So I don't see any big differences. One thing that I did notice when you were talking though is the PCT application process. It sounded like to me you said that the PCT, is it automatically filed or is that by the request or the desire of the inventor? Do you automatically file a PCT for other countries, or does the inventor request that, or is that left up to the inventor to do?
It actually depends upon the vision of the inventor, where he wants to commercialize and in how many countries he wants to commercialize. If it's only India and one other country, there is no need to file a PCT application. He can just file in India, and within 1 year he can file in the other country, example maybe US or Europe, where he wants to apply within 1 year. Sorry, I mean within 1 year. It's not within 1 month. Yeah, within 1 year he can apply, so that the application prior application priority can be taken up. So but if the inventor wants to apply in many countries, then, just to make sure that his pocket is not completely gone, and he can manage his funds, there is a way to file one single application, which is patent international application through PCT. And then this application is a kind of application which can then be channelized in different nationalities, different countries. It's not a patent actually. So it depends if inventor wants in countries like Japan, China, or USA, and some maybe Australia. So these four countries. And if he files independently in these countries, after filing in India within 1 year, it may be expensive for that person and maybe hard. He has to work a lot because he has to talk with attorneys in all these respective countries at the very outset, in the very early stage. So it is good if we can file one single application, and it goes through the process of examination and researching by the one authority who is taking care of it for all the other countries. And once it goes through the process 50 or 60%, and then we can channelize to these four countries. We can hire the attorneys, and they don't take that much fees because already the process, a lot of the stages, a lot of the letters of the process have already been crossed. So this helps in better management of filing applications in many countries through one single application. So it depends upon what inventor wants. So it actually it's not something automatic. It depends what exactly is the business agenda of the inventor. Yeah.
Okay, I see. So it seems pretty. Everything seems pretty similar. Including that PCP process. So we're pretty much on the same level. Now, in the U.S., there are three types of patents: the utility patent, the design patent, and the plant patent. Um, and just speaking specifically about the design patent, we talked about utility. In the U.S., a design patent covers the ornamental design of an article manufactured. And on or about May 13th, 2015, that patent has a term of 15 years from its date of grant. Uh, can you shed some light on the protection of design patents in India?
Okay, so here lies a big difference in India.
Mm,
We don't call it design patents, we call it industrial designs. The
okay.
meaning is same, but the IP right is different here in India. In US, maybe you call it design patents, utility patents, and plant patents. In India, we call utility patents as patents. Okay, and design patents as industrial designs. This is a different category of intellectual property rights. And for plant rights, there is a separate entity, which government entity, which takes care of it, and it's not under the category of patents. It's not protected under the category of patents. So these are different types of intellectual property rights as far as India is concerned, but they are all together as patents in US as far as I know. So the term is again 10 years, extended up to another 5 years, which is 15 years in total. But at the very if we don't apply for extension, it is up to 10 years only. We have to apply for the extension before the expiry of 10 years to get it up to 15 years. With this, I could just I am able to record. You asked me about the term of patents as well. Patents is it is 20 years. I think in most other countries it's the same, in US as well. So this is all about design patents. Yeah.
Okay. All right. Well, that sounds similar, but I think the term is a little shorter, and you have to apply for the extensions in India. Is that correct?
Yeah, it's almost same, almost same. The process, you can say, the forms are different. There are lesser forms, the lesser complications in design patent, because we have to protect the ornamental and aesthetic aspects of the invention in the industrial designs. The meaning is almost exactly the same as in design patents. So it is something which is confused, which confuses inventors. What is this? Is it industrial designs or design patents? In India, they get confused because they hear of two words, two different things, which means the same. The same thing is protected in both. It protects what the invention, if it is a product, it doesn't protect the functionality. Functionality is protected by utility patents, as we call in India patents. And then the aesthetic aspects, how it looks to our eyes, what are the various patterns of lines, and what exactly is invention is to our eyes, it is protected by design patents. The process is usually, it takes lesser time than the utility patents. It takes
Yeah.
we can get it a little more earlier. Here in India, publication happens once it is granted. After that, as far as designs are concerned, um, and we can get it within a year also. Maybe, sometimes in 6 months. I have seen in 3 months as well in India. So it's quite easier, less complex than utility patents. Yeah.
Yeah. Absolutely. Absolutely. Well, just moving on and just thinking about a larger picture of intellectual property. At present, artificial intelligence is all over the news and in everybody's
Yeah.
daily conversation. And now, with the advent of Chat GPT, do you think that the AI generated invention without human intervention should be patented? Why not?
Okay. Now, this is a topic which is a much debated topic, and it is still debated upon, and still we are not able to go this side or that side, and we are not able to, because both sides have their own yes and no's and this and that's. See, we need to understand the basic principle with which these generative AI tools, artificial intelligence, chat GPT based general intelligence tools work, how they work. Actually, the basic funda is how our mind works. This work in the very similar way. Our mind has neural networks, and there are patterns of neural networks which are in our mind. The way we think, the way our thoughts are created. So we get inputs, maybe by reading something or listening to some video, or maybe hearing from some other people from our house, family, or other community members. What we get as an input through our senses, it then enters our brain and creates neural networks depending upon how much we get that information. These neural networks are created. Based on those neural network, thoughts are generated, and then we produce some outputs. Similarly, generative AI tools are working. I have researched a lot on this because it is something of an area of my interest, because my PhD belongs to artificial intelligence based topics. So I'm very curious about this field of study. So it works like this. If it's a mind, then shouldn't it be an inventor? This is a topic which we should think about, because but the contradiction here is, someone out there, a human like us, is giving prompts from outside in the computer, and then only this artificial tool is working. Although though it is giving us outputs and research based results, which are inventions, we call it inventions, but someone out there like us is giving prompts, and someone has developed these tools. A person like us has developed this tool, trained this tool, we call it in this as training. So someone has trained this tool. Then who exactly is the inventor? The person who has made generative AI, or the person who is giving prompts to generative AI as the input, or the generative AI which is analyzing it and giving the outputs? It's actually not the word. Maybe these three people who may be treated as inventors because they have done some percentage of work. So this is a topic which needs to be debated upon. But I must mention here, nothing could be left solely on generative AI tools, because otherwise they may take over humanity. So that's why rules and regulations are being made in US and maybe now in India as well, that a human has to definitely review what generative AI tools are generating, and they have to take the ownership over it. These tools cannot be treated as inventors, because otherwise, where will humanity go? Where will people like us go? Because this is infinite intelligence, this is abundance of intelligence. This is actually more than what our intelligence is, which our intelligence is limited and finite. But this is intelligent of whole internet, and it is growing and growing and growing. It will definitely take over us if we don't bound it, limit it, to not being owners, not being inventors. So this is something which actually, in one line, I don't think that generative AI tools could be treated as inventors. It should be, the ownership should be in the hands of the person who is using this as a tool. Yeah.
Okay. You know what? And I think that's the big time question is who is the inventor? Is it AI or is it the person? I always say, just like you were saying there, it should be the person that programs the AI,
Yeah.
who initiated it and who has followed it along and reviewed it. That's what I always say. But here again, just like you say, it's going to have to be reviewed, and it's going to be a lot more debate around it before we come to a conclusive answer. One last question, and I asked all of my guests this question. In your particular business, the business of intellectual property, what challenges uh, will businesses face in the future? Which ones excite you the most, and which ones concern you the most?
Challenges of converting the business into processes and systems, I think, is the main challenge of any business, I just think. Because unless and until we are able to streamline it as this process of systems and processes, if we do everything on our own, it is a practitioner doing it as a solopreneur. And if you wanted to create it as a business, if you want to be an entrepreneur, you have to learn the skill of delegating, of automating, of converting it into systems and procedures. These are the three things I say. We should be able to how to delegate and how to get the work done, how to get it managed by others without much of your interference, and just look from the back of the screen that the work is getting done, and we are just aware of it through Excel sheets. So this is a skill. This is not that easy, because as a owner, we are very concerned about our clients' work. We think, is it done that way we want, or should we do this on our own? Will that person be doing it the way, the excellence we put in that work? Will the person whom we have employed will be able to do that way? So that is a skill. How to delegate, how to automate is another skill. How to automate in turn means how to create it, a system and a process which is automated, which is going on its own. So this is a challenge which I think I'm facing from quite a long time. I'm trying very hard, and I will be able to accomplish it. Otherwise, I have to, actually. I'm doing it. Yeah. So this is one of the biggest challenge of any business, think, and it takes some time. Other than this, I think it covers everything. This is the biggest challenge. Yeah.
I see. I see. Okay, then. Well, with that, we'll have to bring this podcast to an end. I want to express my gratitude to Dr. Chopra for sharing her expertise and insights, and we are honored to have her to join us on this podcast. And I also want to remind those of you who are watching to take this opportunity to learn from our guests and to strive to achieve your own goals and aspirations. Dr. Chopra, where can we find you for future reference?
For future reference, you can just put my email ID. It's prachi.chopra@intellectbastion.com. My email ID, and my LinkedIn handle is there. I'm on LinkedIn, I'm on Twitter, I'm on all social media channels. I'm more on LinkedIn, Facebook, Instagram. I'm also a YouTube content creator. You can find me on YouTube also. You can find many of my videos on YouTube as well. So you can find me there as well. So these are different social media handles, and you can message me, text me on LinkedIn, and my email ID. These things you can just put it in the, and I can be connected through these means. Yeah.
Okay. And I'm James Bennett with Innovative Solutions. I can be found at www.innovativesolutions.org. That's one N, no E. www.innovativesolutions.org. Thank you for watching today, and we'll see you on the next podcast.
You've been tuning into We Solve Problems with your host, James D. Bennett II. Learn more about financial incentives to mitigate the risk to better your products at www.innovativsolutions.org. where you can find other episodes of this show. Thank you for your positive feedback, comments, questions, and for sharing this with others.